My name is Kruger from Velden-Duffey attorneys, and I asked Elmari Richter to join us today. And I actually saw this in an article. It was discussed in that article whether moving out of a house during divorce proceedings can negatively affect your rights in respect of that divorce. And I asked Elmari to answer that question. So I actually wasn't quite convinced that the article or the arguments in the article were all correct. But anyway, Elmari, please help us. What would you say?
Well, Volker, moving out of the communal home can definitely have an impact on your divorce matter, but it will not necessarily be a negative impact. Moving out of the communal home, more often than not, actually stops the constant conflict and animosity between the parties, which then makes it a lot easier to settle a divorce matter. There's also then circumstances where it's actually unsafe for the one spouse to remain in the household, and then it's better for that party to move out to secure their own safety. But what I always advise my clients is that before moving out, first discuss it with an attorney or a legal person. The thing is that there is certain factors that can impact your divorce matter, and you have to be well informed before making a decision to merely move out. If I can give a few examples of factors that will actually influence the divorce matter when you move out, is the first would be the children. So if you move out without the kids, but you actually want to be the primary caretaker, in layman terms, if you want to have custody over the kids, it's not ideal to move out of the house without the kids. You should take the kids with you if you want to remain the primary caretaker. You know, in a lot of matters, the one parent will move out and will leave the kids in the common home, and then throughout the divorce process, the kids settle well, and then later on the court don't want to reverse the decision. They want to keep the kids with that one spouse because the kids are doing well. So then you actually missed your opportunity to remain the primary caretaker of the kids. In other matters, for example, the parties already discussed and agreed that the kids will stay with mom, so dad may move out, and it will have no impact on the divorce matter at all. I just always advise my clients that whenever you move out, you must stay involved in the children's lives. You must still have an interest in their homework, in their activities, extramural activities, school and the school events. It's important to remain an active and interested parent, even if you move out of the house. Another example would be it may have an impact on a spousal maintenance claim or a possible spousal maintenance claim. For example, I'm going to I'm going to refer to genders, but it can be reversed as well. So
please carefully, no?
Yeah, yeah, I should be careful now. But let's say, for example, the dad moves out of the house and the mom remains in the house. She cannot cover all the expenses, so the dad actually continues to cover all the expenses of the current communal home, and he now starts to incur expenses of a new household. Now the court can suddenly see that he actually can afford to maintain two separate households at the same time. Now the court can see that maintenance is affordable, he can afford to maintain his wife and the kids and himself, so spousal maintenance will then be payable. Or, for example, let's say the husband moves out of the house, but he leaves the wife with all the expenses. She can actually not afford all the expenses, but in some way she managed to cover the expenses. The dad doesn't contribute at all. Now suddenly there's that possibility that she may lose her spousal maintenance claim because the court can see from the way she's managing her affairs that she's actually not financially dependent on the husband that moved out. This is, for example, one way where moving out can have an impact on a spousal maintenance claim. Like I said, it will not always have a negative impact. It differs from matter to matter because all divorce matters differ, circumstances will be different, so that should also be taken into consideration. What also often happens is people tend to move out in quite a rush, so they only move out with their personal items. They leave all the household content and movable assets behind. Now, especially in divorces where the parties are married in community of property, we all know that movable asset should be divided equally between the parties. Now, if you move out only with your personal items with the intention to divide the remaining assets at a later stage, it often happens that the spouse who resides in the home with all the assets sells some of the property, they sometimes damage the assets, and then obviously it will negatively impact your matter, seeing that it will be difficult to recover that movable assets. People also tend to move out, leaving personal documents behind. Documents such as marriage certificates, passports, birth certificates, and all that type of documents are quite important in a divorce matter. We need a marriage certificate before we can issue a summons, etc. At least Home Affairs is available to assist everyone to print out new certificates, etc. But it leaves quite a headache to some of the parties. Like I said, this is just a few examples, Volker. I don't know if you can think of anything else, but it is important that before you move out, that you should obtain legal advice so that you can discuss your specific setup and circumstances with your attorney, and your attorney will then confirm whether it will have a negative impact on you or not, and will advise you to then move out or not. What I prefer to do is I prefer to settle certain aspects in a divorce matter before the client move out. For example, I would like to address and settle the division of the movable assets and the household content, so that when my client leaves the household, they already leave with all the assets that they will retain. Or I will already address all aspects and contact rights and everything in respect of the kids, so that when the one party move out, there's already a proper agreement in place in respect of when the kids will visit the parents, when they will sleep over, etc. And that then also protects the client's interest. But like I mentioned previously, there's some certain circumstances where it's unsafe to stay in the household, and in that matters, it's always better to move out. There is ways to protect yourself if you had to rush out of the home.
I have to admit, it's far more complicated than I initially thought when I read that question as to whether it can negatively impact your divorce when you move out. My initial thought was surely it can't, because in terms of the propriety consequences of the marriage, when you married in community of property or with the accrual system, surely the consequences would be the same whether you move out or not. By moving out, surely you don't renounce any rights that you would otherwise have had. But I understand what you're saying, and it just shows to show you what difference it makes if you specialize in a certain field of the law. I don't do divorces at all, but with your experience, it's clear that one should certainly first consult your lawyer before you move out, before you take that decision, to make sure that you don't have those problems that you explained now. Maybe I can just also ask you briefly. You mentioned now the fact that it could also solve some problems, if there's conflict, etc., if you move out. Maybe just in terms of family violence interdicts, just refresh our clients, our listeners' memories in that respect. What can you do if there's a problem with that?
Yes, well, definitely if there's harassment or there's abuse, verbally, emotionally, even economic abuse, which we often see in divorce matters, then there is a process that we can follow in court where we obtain a domestic violence protection order. Now, this protection order will actually interdict the other spouse from certain actions or whatever. For example, you can move out of the house, you are quite afraid that there's a lot of abuse, the person is intimidating you, then you can move out of the house and we can obtain an interdict. That person then may not enter your new residence, or that person may not come to your workplace, or may not call you and harass you or verbally abuse you. So there's a lot of ways to protect a spouse in a divorce matter as well. So if you actually need protection in a divorce, we obtain an interdict. It's sad to say, we often also see in divorce matters where people abuse this process, where they obtain interdicts without actually abuse being present or intimidation or harassment being present. So I always first consult with my clients to actually determine whether we are now abusing a process or whether we are actually in need of this protection. This type of interdicts also raises the conflict in a divorce matter. You know, you set the tone for the divorce matter. It's not always then easy to settle a matter. When your client actually needs that protection, it's ideal to have it in place. But when you are merely obtaining an interdict to frustrate your spouse, to show him who's boss and who's going to run and handle this matter, then it's not ideal. Then you are actually frustrating the divorce process a lot. But I always tell my clients they know exactly when they actually need this type of protection. They know the setup in their households better than anyone else, and that's also where you need to obtain advice. Once again, with this protection orders, if there's a lot of abuse, especially physical abuse or intimidation, you can also approach the court directly if you don't have the finances to obtain the assistance of an attorney, and you can approach the court directly to have this interdict set in place. We have some high conflict divorces where before we even tell the spouse that we are getting a divorce, we first obtain the protection order to make sure that this person is protected, seeing that we don't always know how the spouse will react. But like I said, that's very specific circumstances. Not all divorces go hand in hand with a protection order. And I often see colleagues abusing the process, which is quite unfortunate.
And you can get that order at the local magistrates court. You don't have to go to the High Court. It's not an expensive process. It's fairly quick to obtain that order. But as you said, then also opens the doors for it to be abused. No? Because if the respondent against who the order is given then transgresses the order, you can go to the police and lay a charge, and he would then typically, or she would be typically arrested after that.
Yes, the police immediately goes to remove that person from the home, and then they will be taken to court. What's also important with a protection order, and I think it's worth mentioning, is that I always inform my clients and tell my clients that the order that you obtain it comes with an obligation. And the obligation is actually to inform the police or your attorney or whoever if that person is not obeying the order. No one will actually know if that person is complying with the court order or not. So you have an obligation to enforce that order. If the person comes to your home and he's not supposed to be there, no one will know it. Then that order is with the paper it's written on. But if you then call the police and if you then take action to enforce that order, that's where the protection lies.
Okay, interesting. Thank you, Elmari.
Thank you, Volker.